everyone, it's Michelle, Mary Sue, and Stephanie. Thanks to Nolan, Travis, and Andra for laying out Social Benefits Tribunal Part 1. Now we're going to talk about the Social Benefits Tribunal Part 2. Practice direction, policy directives, policies, and decisions.
Let's get right into it with practice direction. From here on out, I will refer to the Social Benefits Tribunal as the SBT. Practice direction has been made to provide guidance about what the tribunal expects of the parties and in turn what the parties can expect from the SBT. It assists in understanding the rules. Practice direction on representation lays out the foundation of who's considered representation in the SBT. Very basic stuff, just lays out the definitions of who's who, whether licensed lawyer, paralegal, unlicensed support people, or self-represented. The practice direction on litigation guardians deals with making the process to justice accommodating for persons with disabilities and in particular persons with cognitive disabilities. Practice direction on interim assistance deals with what assistance may be available to persons awaiting their hearing and may be having financial difficulties. This would include basic financial assistance, income support, drug and dental benefits. Practice direction on reconsideration requests are dealt with on a case-by-case basis. It allows for reconsideration hearings where a serious error or omission has occurred, while trying to discourage unnecessary requests. In exercising its discretion here, the SBT balances the public interest in preserving the finality of its decisions with the need to address substantive problems in decisions of the SBT without a judicial review. Practice direction on electronic hearing is, you guessed it, means a hearing held by a conference telephone or some other form of electronic hearing technology. During the process of a hearing, it may be determined that another hearing format may be more appropriate and may direct the hearing to be rescheduled. Practice direction on rescheduling of hearings and adjournments. The SBT expects that everyone is prepared for the hearing on the date and time contained in the notice of hearing, unless the SBT agrees to change the date or time. Requests to change a hearing date must be made as soon as possible, and the requester must provide alternative dates. These new dates must be within 60 days of the original scheduled date. The SBT gives parties 30 days notice of hearing according to the timeframe guidelines. Practice direction on early resolution opportunities deals with providing the parties with an early opportunity to try to resolve before the SBT hearing process begins. In addition to resolving the issues on the appeal on a full and final basis, participation in an early resolution opportunity can enable the parties to share and exchange information, consider which issues will be dealt with at the hearing, and whether the issues can be clarified, narrowed, or simplified. Practice direction on human rights issue or challenge. The SBT has jurisdiction to consider challenges to the Ontario Disability Support Program Act 1997 and the Ontario Works Act 1997 under the provisions of the Human Rights Code. A code challenge must provide the following information: the social area of the alleged discrimination under the code, the ground of the alleged discrimination under the code, the relationship of the claim of the alleged discrimination and the ground selected, and the reason for the alleged discrimination. Evidence must be relied on to support the claim of the alleged discrimination and the desired remedy and resolution. Practice direction on recording proceedings. The SBT will not prepare and produce a transcript unless served with a notice of appeal. And lastly, practice direction on pre-hearing conferences. A pre-hearing conference can reduce the length and simplify a hearing by helping parties to prepare properly for the hearing and by prompting pre-hearing disclosure of each party's case. The effective use of pre-hearing conferences allows the SBT to conduct more efficient, focused, and effective hearings.
Hi everyone, it's Mary Sue. Now it's my turn to talk about the Social Benefits Tribunal Policy Directives. The Social Benefits Tribunal was created under the Ontario Works Act and given additional powers by the Ontario Disability Support Program Act, and therefore it receives its policy directives from both. The SBT hears appeals related to social assistance matters concerning Ontario Works benefits and the Ontario Disability Support Program. As such, the policy directives provide procedural information on the appeals process for both Ontario Works and Ontario Disability Support Program. I bet everyone is dying to know what the policy directives are and how they work. You should. You may be representing someone someday, and you'll need this information. So hold on to your briefs, because I'm about to give you the lowdown. To begin, I'll explain the policy directives for Ontario Works as they apply to the SBT. Section 10.1 is about the notice and internal review process. To be eligible for Ontario Works, the applicant must live in Ontario, need money right away to help pay for food and shelter, and be willing to cooperate with the agency in finding them a job. When people apply to Ontario Works, they have to give the agency information about their family size, income, assets, and housing costs. Of course, if people were refused assistance, there would be no purpose for a tribunal. So when people are refused, they will first receive a notice of decision. A decision has to let an applicant know whether or not they are able to appeal to the tribunal. An internal review is required prior to appealing a decision, and there is a 30 calendar day time limit in which a person must ask for the review. If a review is not completed within 30 days and the decision can still be appealed to the SBT, the applicant is notified of her right to appeal the decision without the review. Section 10.2 speaks to the appeal process. As stated, a decision may be appealed to the Social Benefits Tribunal only after an internal review has been completed. In a nutshell, the applicant has, you guessed it, 30 calendar days from the receipt of the internal review decision to file an appeal. If an applicant is granted a hearing, it can either be conducted in a written or oral format. While the applicant is waiting for a decision by the SBT, she can request interim assistance if there is a certainty she will suffer financial hardship during the appeal process. Section 10.3 is about recovery of interim assistance. SBT has the authority to order payment of interim assistance, in other words, financial aid, only if the tribunal is satisfied that the recipient is experiencing 1, financial hardship, or 2, where there are grounds for an appeal, or 3, when other conditions of eligibility, except those under appeal, have been met. When a person receiving interim assistance loses an appeal to the SBT, withdraws an appeal, or has an appeal denied, the agency will recover the money as an overpayment. Now, Ontario Disability Support Program and its policy directives. Section 13.1 is a notice of decision and internal review process. This policy directive sets out the requirement for written notice of decisions and the internal review process. The policy's objective is to ensure that applicants receive clear written notice of decisions and information about the internal review process for ODSP benefit eligibility requirements. A paralegal can follow it to navigate the first step of the appeal process if an applicant is denied disability benefits and wishes a hearing before the SBT. Section 13.2 is all about appeals. In this section, a paralegal will discover this policy provides an applicant the opportunity to appeal decisions affecting their eligibility for income support, both decisions to suspend, cancel, reduce, or deny income support. An appeal cannot proceed unless an internal review has been requested by the applicant. 30 calendar days of receiving the notice of decision is the magic number to make a request. Most decisions affecting eligibility for the amount of income support, including assistance for children with severe disabilities, are appealable to the SBT. And finally, Section 13.3 is recovery of the interim assistance. As we've learned, the SBT can order payment of interim assistance if it is satisfied with the recipient will suffer financial hardship during the time it takes to complete the appeal, and the conditions of eligibility other than those under appeal have been met.
Thank you, Michelle and Mary Sue. I'm going to review some policies now. These policies are under the umbrella of the Social Justice Tribunals Ontario. The first is the Accessibility and Accommodation Policy. It ensures that all members of the public have equal access to the provided services of the tribunal. This is accomplished through the commitment to providing accommodation for needs of the public as outlined in the Accessibility for Ontarians with Disabilities Act, as well as following the principles outlined in the Human Rights Code. We know the Human Rights Code provides accommodation relating to specific factors, some of which are race, ethnic origin, creed, sexual orientation. The dignity and independence of the public should be respected, and the services should be provided in a manner that promotes physical and functional access to the tribunal. Qu'est-ce qui se passe quand je vous parle français? The French Language Services Policy also deals with accessibility, specifically the access to communicate and provide the services of the Social Benefits Tribunal in French. A person has the right to French services of the tribunal and the right to submit and receive documents in French. This includes the right to a bilingual adjudicator, mediator, as well as an interpreter when required. Is everyone still with us? Great, because now we are going to go over some relevant court decisions. You may see these cases when researching decisions made by the Social Benefits Tribunal. The case of Gray v. ODSP is important because it provided an interpretation for the definition of person with a disability. Specifically, the interpretation of substantial impairment. It was decided that the ODSPA is intended to encompass a broader section of society, and the word substantial should be given a flexible meaning for the circumstances of each individual case. Assistance should be provided to persons with significant long-term functional barriers, not only those suffering from severe long-term functional barriers. ODSP v. Crane was an important case in affirming that three elements must be met when interpreting the definition of person with a disability. The onus is on the claimant to establish all of the criteria, and if one of the criteria is not met, the tribunal does not need to deal with the other factors. The criteria are substantial impairment, substantial restriction in certain activities, and verification. In Sandiford v. Ontario, it was decided that where the court states that verification is intended to weed out suspicious claims, and in the event there is an arguable basis for verification, the tribunal ought to proceed with an analysis of the substantiality of the impairments and restrictions on the basis of the evidence as a whole. In Omar v. Ontario, it was decided that the tribunal is required to consider medical evidence only if it relates to the appellant's condition at the effective date of the director's decision. If there are impairments arising from a new medical condition, or if there is a worsening level of impairment after the director's decision date, the person can reapply. And of course, as a licensed paralegal, what should one always do when using any case law? You know this one. That's right. Note up. That concludes our presentation today on the Social Benefits Tribunal. Thank you to everyone for their attention. Does anyone have any questions or comments?
I'm Dennis, and I may be overthinking this, but I think this was the best presentation ever.